Hello, everyone. Welcome to Lecture 5 entitled Safety of Passengers. Note that extraordinary diligence of common carriers owed to passengers cannot be dispensed with or lessened by stipulation, by the posting of notices, by statements on tickets, or otherwise. When a passenger is carried gratuitously, a stipulation limiting the common carrier's liability for negligence is valid, but not for willful acts or gross negligence. Negligence on the part of the captain and crew as well as the operator includes failure to comply with the regulations issued by the Maritime Industry Authority on the safety of the passengers. Memorandum Circular 112 provides that the carrier is bound to carry the passengers safely as far as human care and foresight can provide, using the utmost diligence of a very cautious person, with due regard for all circumstances. The passengers have the right to be treated by the carrier and its employees with kindness, respect, courtesy, and due consideration. Roadworthiness means that common carriers that offer transportation by land are similarly required to make sure that the vehicles that they are using are in good order and condition. Thus, the carrier will not be excused from liability on the ground that the tire blowout was due to fortuitous event, when it was shown that the passengers were injured because the floor of the bus gave way. This is true even if it can be established that the tire that was subject of a blowout is brand new. The duty to exercise extraordinary diligence requires the carrier to purchase and use vehicle parts that are not defective. Article 2185 of the Civil Code provides a presumption of negligence in case the accident occurs while the operator of the motor vehicle is violating traffic rules. For the presumption under Article 2185 to operate, there must be proof of violation of traffic rules. On the other hand, for the presumption of negligence of common carriers under Article 1756 to operate, all that is required is proof of death or injury to a passenger. Nevertheless, in cases involving breach of contract of carriage, proof of violation of traffic rules confirms that the carrier failed to exercise extraordinary diligence. In quasi-delict cases under Article 2176 in relation to Article 2180 of the New Civil Code, the employer can invoke the defense of due diligence in the selection and supervision of the employee in order to escape liability. Such defense is not available if the case against the carrier is based on contract or culpa contractual. A carrier is ordinarily not liable for injuries to passengers from fires or explosions caused by articles brought into its conveyances by other passengers, in the absence of any evidence that the carrier, through its employees, was aware of the nature of the article or had any reason to anticipate danger therefrom. In overland transportation, the common carrier is not bound nor empowered to make an examination on the contents of packages or bags, particularly hand carried by passengers. If an airline company was involved, however, it is duty bound to inspect each and every cargo that is brought into the aircraft. In one case, the Supreme Court held that hand carried luggage of passengers are governed by the rules on necessary deposits. Under Article 2000 of the Civil Code, the responsibility of depositary shall, among other cases, include the loss of property from force majeure. Article 2001 of the same code considers an act of a thief as not one of force majeure, unless done with the use of arms or through an irresistible force. In another case, the Supreme Court held that the carrier had the duty to exercise extraordinary diligence over the baggage that was turned over to the carrier or placed in the baggage compartment of the bus. The fact that the maleta was not declared nor the charges paid thereon would not be material so long as it was received by the carrier for transportation.
So that's it for today's lecture. Thank you so much for listening.